Awesome. Well, good evening, everyone. Thank you so much for joining us tonight for the Physician Immigration Update 2025 webinar with Elissa Taub. While I give everyone a few minutes to log on, I'll go ahead and introduce myself. My name is Rainey McNeely. I'm the Physician Engagement Specialist here at Practice Match. If you've attended any of our in-person career fairs, any of our virtual career fairs, and gotten a gift card, if you've ever submitted a CV for review, that all comes from me. I just want to remind everyone tonight that this webinar and the career fair that we hosted before are not our only free career resources that we can offer you during your training and after. We also have things like scholarship opportunities, free CV builder and review, and more. We have a job board. You can check out our website to find all of those things. I do want to remind everyone tonight this webinar is being recorded. So I'll send you the link to the recording by the end of the week. Your microphones and cameras are muted. So if you have any questions, just please make sure you put them in the Q&A chat box. Not just the regular chat box, but the Q&A chat box. And by the end of the night, Elissa will get all of those answered. It looks like we've got some good attendance. So Elissa, if you're ready to go.
Fantastic. Thanks so much, Rainey, and it's great to be with you, with all of you here tonight. We, as the title of the presentation today, signals, we're going to talk about some immigration updates. Just to give you a little bit of background about me, I'm an immigration attorney. I'm a partner with the law firm Siskin Susser, and I head up our firm's healthcare immigration group. So most of what I do is immigration for healthcare workers, and a lot of that is for physicians. I co-author a book called the Physician Immigration Handbook, which you may have obtained through Practice Match. If you've not, you can obtain a digital copy of that, or you can contact me for a hard copy. But I've been doing this work for a little over 18 years, and I've been practicing law for 25 years, which is kind of ridiculous. And so I'm happy to talk with you tonight about immigration issues. I know there is a lot of anxiety, a lot of fear and frustration about how this process might work. And some of that we'll talk about tonight, some of the things that it is correct to be concerned about and things that are going on current events wise. And then some things that maybe you might be unaware of that are actually working out pretty well and like normal right now, which is hard to believe. So we're going to kind of do a deep dive into all of that as much as we can over the course of the next hour. As Rainey mentioned, you can put questions in the Q&A. I will monitor the Q&A while we are going through the presentation. So you do not have to hold your questions to the end. If I see a question in the Q&A that is relevant to what I'm talking about in the moment, I'm going to answer your question live in the moment. If you hold it to the end, that's fine. But you don't, I just want you to know that you don't have to do that. The other thing is that as you can tell by the number of people who've already logged on and will continue to log on during this presentation, this is not a confidential legal advice kind of setting. We are not going to be able to do individual consultations in this kind of a setup. So please do not include super personal information in your questions, because everybody who's on this webinar and people who view the recording will be able to see the information that you share in the question. And I'm not going to be able to give you confidential advice. This is not intended to create an attorney-client relationship amongst or between us, but really more of an informational thing so that you all have relevant, up-to-the-minute immigration information that you can use. So with all of that preliminary stuff out of the way, let's get started. And we're going to actually start off with some general immigration updates. And we're going to spend a lot of time on the first couple of slides of this presentation talking about things that aren't necessarily like solely relevant to doctors, but are things that you should be aware of as a person who might be in the United States in a non-immigrant status, meaning you have some kind of visa, J, H, or something else, And there are, things going on. Everybody's consuming media. Everybody's trying to figure out what's happening. People are hearing rumors. We're going to talk about those things first. And then we're going to pivot and talk about how things are going in J1 waiver world, and specifically talk about some stuff that's going on with doctors. So first things first, what you've seen in the news. There are three things that you've probably seen coverage of in national news. One are breathless, high anxiety reports of crazy things happening in the immigration world. Two are concerns regarding international travels, horror stories of things happening to people at airports when they go through Customs and Border Protection inspection. And the third thing is regarding the termination of TPS. So I want to talk about each one of these three topics individually. And then we're going to talk about some things that are kind of hot topic-y that you probably haven't heard about or seen in the news. So the first thing is I want to start off with the biggest elephant in the room when it comes to immigration, which is that all of us likely are consuming media, consuming news on some basis. You're watching TV, you're reading on X or Blue Sky or Threads or Instagram or Facebook or Telegram or somewhere, right? We're all consuming information. And everybody all of a sudden will start to share some viral article about some horrible thing that happened to somebody in the immigration context. They were denied entry at the US border. Their green card was rescinded. They weren't allowed to, they didn't get an H-1B visa. They had a visa revoked, all kinds of things. And I want to caution a little bit about some of those reports, because in the beginning, in February, early March, we immigration lawyers were getting swept up in a lot of these high anxiety reports as well. And we were like, oh my goodness, everything is haywire. And there are a lot of things that are haywire right now. But one thing to note, and one thing after we started learning more details and more relevant facts about a lot of the situations that were reported, was that there were actually reasons why the government took the actions that they did. Now, maybe they went away, the way they went about it wasn't normal. Putting somebody in detention before they remove them from the United States versus just putting them on the next plane, which would have normally happened. There are things that were certainly departures. But when we looked at the facts of the situations, a lot of those kinds of cases might have happened anyway under a prior administration. They just weren't necessarily reported, or maybe the action that CBP took wasn't as extreme. I'll give you a couple of examples of what I'm talking about. The first were there were some early on some reports about young women who were traveling to the United States from Europe who were detained in ICE or immigration detention for a week to 10 days before they were told to leave the country. And they were trying to come here as visitors, just to go backpacking or, for tourist reasons, like nothing super crazy. And they were young, and they, didn't really, they never had any immigration violations in the US before. These people weren't criminals. They weren't trying to do anything wrong. But then, like, for example, in one case, it came out that these two young women were, wanting to backpack through the United States, and they didn't have any hotel rooms booked. They didn't have any accommodations booked. Even if it wasn't a hotel room, they had no idea where they were going to stay, and they hadn't booked their return flight home yet. Those are two big red flags for CBP when somebody tries to come to the border as a visitor, that they, one of the things you have to prove when you come to the US as a tourist is that you're actually going to leave and you don't have the intent to stay in the United States permanently. Now, in normal times, CBP would have said, look, we're not going to allow you in, but we're going to let you withdraw your application for admission and just book yourself on the next flight home or somewhere else, but you just can't come into the States. And that would have been the end of it. With these young women, they were put into immigration detention for a week, 10 days, 2 weeks, before the government got around to removing them. And my personal opinion is that that was done to them to make a point, that things were different. The government was going to take a different approach. But on the law and on the fact that these young women weren't allowed into the United States wasn't really a departure from policy. But the initial reports that came out were, pictures of these young women from Europe who were put into immigration jail. And, everybody just kind of went nuts. And then it turned out, well, maybe they weren't the smartest in putting together their itineraries to the United States. They weren't well informed about what the requirements were. So you can kind of see how the journalist reporting on some of these stories where the journalist maybe isn't super familiar with the immigration policies or the immigration rules, they're thrust onto this beat, and all of a sudden they're reporting something breathlessly that we immigration lawyers might say, well, hold on a second, right? It's bad, but it's not quite as bad as what is being reported. And we want to make sure that when we're consuming news, we're not allowing ourselves to get swept up into some, tizzy of misinformation. We want to make sure we're being kind of fair and balanced in the way we're consuming it and the way we're reacting to it. So that's just one example. But I want to emphasize that it's really important as we read these reports. There are times where I'm like, yeah, I don't get this. There was a story recently about a man from I think Chile, or Peru, no, Chile, who was living in the United States. He had been granted asylum here many years ago, had a green card for many, many years, and his green card was lost or stolen. And he went to the immigration service to replace it. And rather than replacing it, they deported him now to a completely different country. And he was a permanent resident, and I keep looking for subsequent reports to see, like, okay, well, was there something going on in the background? Because he didn't have any criminal background. There didn't seem to be any reason for that to happen. That's a case where I'm like, okay, I'm going to reshare this and I'm going to say, look, I don't really see a reason. I can't speculate as to what happened in that man's case. That seems really bad, right? So I can acknowledge when things are bad, and when the government seemingly did something that wasn't justified. And I can contrast that when they're really following their own policies, but maybe they're being a little more aggressive than they normally would, right? There are differences in those stories. So, you know, I want to acknowledge that. I want to acknowledge that those stories create anxiety throughout the immigrant community. It creates anxiety with immigration lawyers because it's very difficult for us often to advise our clients on best practices and proper steps when it seems like the bar keeps getting, raised for, things that we need to be cognizant of as the government changes its mind on a daily basis. But I think it's really important to, take a step back, not have the first reaction be complete outrage and say, I wonder if there's something to this. Let me, let this story simmer a little bit and see what's really going on here. Is this something I really need to be worried? Do I need to upend how I've been doing things because of this one example? Or is this an outlier for some justifiable reason? So, that's an important thing. So I wanted to touch on that right off the bat because, I see this every single day. I'm sure all of you do as well. And I get a lot of questions from clients, and I'm glad they bring them to me about rumors. And I'm like, yeah, this one's real, this one's not. Here's what we need to do. No, you don't need to do anything about this, right? So I help my clients navigate through the information environment as well. So one of the things, though, that kind of was real early on in this administration, the first part of 2025, and that we're still advising clients on is with regard to international travel. Early on, we saw folks, we saw some high profile cases of people being denied entry. There was the one case with a kidney transplant physician up in the Northeast who was denied entry on an H-1B, and it came to light later that the government had objections to some content that she had on her phone. And there were other cases where that's what seemed to have happened, that somebody had what the government felt like was objectionable content in an electronic device, and that caused them problems at the border. So as soon as we started to see some connections amongst those cases, we started advising clients, hey, when you travel, be really careful with what's on your electronic devices. Be careful about your social media usage. Pictures, if you're in large chat groups, large group chats in like WhatsApp or Telegram or apps like that, and people are sharing pictures and you click on it and it gets downloaded into your gallery, that's now on your phone. And you may not even realize that that photo is in your gallery. You may have deleted the text, but the picture is still there. And perhaps some CBP officer thinks that that picture is objectionable for some reason, and they put you in secondary inspection and give you a hard time. Somebody flags it somewhere. So we started advising clients on some best practices with regard to electronic devices, maybe using special devices that you're using just for international travel that don't really have anything on them, powering down devices on your way into the United States in case the government is trying to use any kind of software to scan what's in the cloud as you enter. I just entered the United States on Friday from a trip abroad, and I had all my devices in the completely powered down and off as I went through immigration. That I probably didn't need to, but I did because I just didn't want to leave anything to chance, on my way back into the state. So there were some things, because when you come to the United States, when you come to the border, even though your flight may land at JFK Airport in New York, when you're not, before you get actually admitted into the United States, the law sees you as an applicant for admission. So physically, yes, you are standing on US soil, but legally you are not yet until an officer of the United States, a CBP officer, you know, hypothetically, digitally stamps your passport and allows you to come in. And so for that reason, when you come to the border, your constitutional rights against search and seizure don't really exist the same way that they do once you're in the United States fully. That means that a CBP officer can place you in secondary inspection at the border, they can question you, and they can ask you to allow them access to your digital devices. And if you don't give them that access, they are going to request those devices from you, and they're going to get access to them on their own, which is probably going to be way more destructive than if you open the device for them. They do not need a warrant for those searches. There is case law that says that. That predates this administration, even predates the first Trump administration. It's pretty old precedent. So, know when you come to the border that your laptop, your phone, if there's some reason for the US government to believe that there's activity you've engaged in that they don't like, they have the ability to search those devices. How this sometimes comes up is that you may be abroad, you might apply for a visa stamp at a US embassy or consulate, and maybe the consular officer has some suspicions based on your conversation, but they're not allowed to search your device. So they put something in the system that flags you so that when you come to CBP and you try to enter the United States, you're flagged for secondary inspection so that CBP can then go and check your phone or check whatever device it is. Sometimes people now ask me, because we're having this whole conversation and I keep saying objectionable content or something that the government thinks is objectionable. What does that mean? And the answer is, I'm not 100% sure. And that's part of the hard part with this. You can glean from the administration's executive orders on anti-Semitism that they're looking for anything that they may think might be remotely anti-Semitic. It's again, that's not a great definition. And you can also glean from some of the public statements and things that overly anti-government, anti-US sentiment in social media posts, in conversations on your phones, may be problematic. Does that mean that every person who's not a fan of this administration is getting flagged for secondary inspection and banned from the United States? No. Does it mean that everybody who has opinions about the Israel-Gaza conflict is getting banned from the United States? No, but it does mean that kinds of content may put you at a higher risk for inspection. So it's just important to be very aware and careful about electronic devices at the border. It'll be hard for me to get too super specific, but on that, there's a great question here, is that if your device is powered all the way down, do you have to power it on for them to search? The answer is yes. If they ask you to search your device, you do have to turn it on. The reason that I've turned it off and that other attorneys have advised to turn off the device is that there's some concern that the government may be, using some kind of software or other device to sort of scan, what might be in the cloud or transmissions that are going on. And I don't really know enough about the technology to know if that's a reasonable concern. But other folks have suggested to me, you know what, when you come into the United States, power down your devices so that there's nothing pinging, as you're trying to enter the country. Now, if you get placed in secondary inspection and CBP says hand over your phone, you still got to hand over the phone, and turn it on for them and access it for them, in whichever way that they want. The other thing I'll mention real quick, because sometimes this becomes a concern, is, I'm an attorney, right? I have a lot of attorney-client privilege information in my electronic devices. I have, my phone is here. I am constantly answering client emails on my phone. I answer client emails on my laptop. I have research information that is in my devices, because that's, how we work, right? We're very mobile. For attorneys who come to the border, and I guess other folks who are protected by privileges as well, and that may include physicians, if there is privileged information, meaning very confidential information that you are not at liberty to divulge, that is in your device, you can tell the officer that there is attorney-client privilege protected material in your phone, or there is, doctor patient privileged material in your phone, and that you don't feel comfortable turning that over to them without a privilege review. In that case, that doesn't mean that you don't have to turn it over. It just means that it will go through a special screening process where you actually get to tell the officer where the privileged material on the phone is, and they're not allowed to review that. And that was very important for me, because I don't want some CBP officer to be like, oh, well, we can find out about all of these clients that she has by looking at her phone. And so that's why they have those procedures. So that's just something helpful to know about as well. The other thing I'll mention about international travel before we move on to some more substantive stuff is with regard to consular processing. A couple of months ago, all the news, everything we were talking about were F1 visa revocations, right? And CVIS terminations. I mean, the last webinar that I did for Practice Match was on April 23rd, and we talked a bunch about that. And there was litigation, and, there's still some wrangling going on with the administration about that, but largely the government lost pretty much every lawsuit that was filed during that time, or they've settled them. And so that issue has kind of quieted down. Still, with regard to consular processing, what we're seeing is a heightened incidence of the government using a section of the law called 214B to refuse visas. This is different from administrative processing, right? Administrative processing, if you've ever been through it, you get what's called a 221G letter, or they'll say your visa is refused under 221G. That typically means that the government has to do a little extra work before to make a decision on your visa. And in a lot of those cases, the visa ultimately issues. What they're doing is an extra background check, or if it's an F or a J visa, they may be doing that famous social media review that you guys have probably heard about, where you have to turn all your social media settings to public so that a consular officer can review. There may be, just a system error where your case, your approval hasn't shown up in their system yet, and they're doing some necessary checks to make sure that they're authorized to issue your visa. So administrative processing a lot of times is just administrative. 214B is a different animal. It is actually a denial of the visa, and it's done for two different reasons. One, the consular officer determines that you just are not qualified. You don't meet the requirements of that section of the law for you to get your visa in that category. And the other is a determination that you don't have strong enough ties to your home country to justify the issuance of the visa in the category. A lot of times, if you're refused under 214B, they won't tell you which way, under which of those prongs they're doing it. They just say 214B. Sometimes they'll specify. It can be challenging to rebuff a 214B denial. Now, I'm not seeing this happen a lot in the H-1B context. I'm not seeing it happen super often in the J-1 context. Where we're seeing it happen is in other categories where the government is a little bit more skeptical. We're seeing it with students. We're seeing it with religious workers. We're seeing it sometimes with O1s. We're seeing it with Ls. So it's a variety of different business immigration categories that we're seeing this uptick in 214B denials. It's something to know about. There's nothing I can tell you in particular that would 100% avoid a 214B denial. What I would say is make sure if you're going to consular process a visa that you know what's in your H-1B petition. Or what's in your J-1, what's in your DS 2019. And what I mean by that is, for example, if you're in a residency or fellowship right now, this is not going to be relevant to you, but as an attending physician, it could be. And this is a good example for you to see where people can get tripped up. You're a hospitalist physician. You work for a hospital medicine management company at a particular hospital. So you're working for company A at hospital B. You're a hospital medicine physician. Your H-1B was sponsored properly by company A. Company A pays you. They deal with all your benefits, all of your, basically all of your employment is managed by company A. But every day when you go to work, you're going to hospital B. And the people at hospital B are your coworkers. And you think of yourself as working for hospital B because that's where you go every day. And you go and you apply for your visa, and the consular officer doesn't ask you a lot of questions, but they say, so who do you work for? And you say, I work for hospital B. That's a red flag to the consular officer because you don't work for hospital B, you work for company A. Those are the kinds of things where sometimes people get tripped up on a consular application and the officer gets like a little bit skittish about issuing that visa because they think, there's something not quite right here. Somebody's not telling the truth. Who does this person really work for? When all you did was make a very honest mistake about who your employer was or where do you work, or maybe you misunderstood the question, right? Know what's in your employment, know what's in that H-1B. Who's your employer? What's your position? Where do you work? What's your rate of pay? All of that is in the I-129 petition. It's all, a lot of that information may be in your, in the petition. It's in your employment agreement. It might be in your approval notice, some of it. Be familiar with those basic terms and what you do. Be able to, have a very short 1 or 2 sentence explanation about what you do. For physicians, this isn't as big a deal as it is maybe for people in the IT industry who are working as contractors, or for people in other, fields where a consular officer really might not be familiar with what the person does. But you would be shocked, especially like with USCIS, when I file some petitions, that they don't really know what a nephrologist does, right? Like we have to say it's a kidney doctor, right? This is a doctor that deals with the diseases and conditions of the kidneys and renal system. So understand that the consular officer you're going to see when you apply for that visa, they, the only doctor they may have ever seen is their internist, and they don't really know what all the different specialists do, and they don't know how doctors become doctors. Like this isn't their area of expertise. And so be prepared. You may not have to answer any questions. You may only have to answer 2 seconds of questions and they grant the visa. Better to be prepared than not prepared. So I would definitely recommend, knowing what's in your petition before you go for your visa interview. And that goes for while you're in training and even when you're in attending, right? Things don't change during that time. Okay, so let's move on to some other stuff. The other thing that you've probably seen in the news is news about TPS terminations. TPS over the years, a temporary protected status, is a status that the president can designate for any people from any country where they say it's going to be too dangerous to return for whatever reason, due to a natural disaster, due to civil unrest, whatever it might be. TPS has been issued for a whole host of countries over the years: El Salvador, Nicaragua, Haiti, Honduras, Yemen, Syria, Afghanistan, Venezuela, Cameroon. I mean, like a huge list. It's like 13 or 15 countries where there have been TPS designations. And one by one, this administration is terminating them. Some of them they've tried to terminate early. Some of them they're trying to terminate when they naturally expire. Every single time they take one of these actions, there's a lawsuit filed. And the lawsuits have gotten really, really complicated, and the outcomes are very confusing. because we have some judges that have halted the terminations and then others and then let them go. And so you have like, on one day there's TPS for one country, the next day it's gone away, and then the next day it's back, and then like 3 weeks later it's gone away again, and it keeps flip-flopping. We actually have one lawyer in my office who is tasked for updating a chart on what the heck is going on with TPS. So it is very complicated. What I want to say about this is not to go through every country and give you a specific update, because that could be an hour in and of itself. But if you have TPS and that's your only status, or if you have it at all, or if you have a friend or a relative who has TPS, if they haven't already, it doesn't matter where they're from. They really do need to seek legal advice on other options, because our assumption is at this point that this administration is going to try to terminate every country's grant of TPS. And I think there are a bunch of them that were set to expire this year. There are others that are set to expire next year in 2026. Don't wait until the last minute. Don't wait until the litigation is done. Make sure that there's a backup plan in your brain, in your pocket, that if your TPS is going to go away, what your next step is, or taking that next step before you get to that point, so that you're not kind of left in a dire situation, if your status is upended right away. So that was my main thing in putting the TPS termination on here. It's like an ongoing saga with every country, and they're all just in different states of granting or not granting, and extended or not extended. So, the most important thing I can tell you is to talk with your immigration lawyer about your options in the event that your TPS is terminated. Okay. Hey, we can finally go to a new slide. So some things you haven't seen in the news, or maybe haven't seen. The first thing, and this is very hot, it just came out, I think yesterday. What's today? Wednesday, maybe Monday. My days are running together. USCIS announced that the H-1B cap for the fiscal year 2026 has been met. What this means, this relates to the annual limit on the number of H-1Bs that can be issued annually. For those of you who are in training who might be in H-1B status, the likelihood is that your H-1B is exempt from this cap because you're doing your training at a nonprofit hospital that has a teaching affiliation with a university or college. And so that hasn't been an issue for you. But when you go to work on an H-1B for a for-profit employer, this cap rears its ugly head because it will apply to that for-profit employment if you've only ever been in H-1B status. So typically we have to go through a lottery for those H-1Bs. The lottery opens every year in March. And in the past several years, what happens is the lottery opens in March. The government selects a whole bunch of cases. People file their H-1Bs, and then, but a lot of other people don't, and then, or some get denied or whatever it is. And then come July, the end of July, they do a second selection because they haven't met the cap. They haven't picked enough cases to meet the quota. This year, they met the quota after the first lottery. So what this means is that there's not going to be a second lottery in July. So if somebody filed an H-1B cap registration in March and they weren't selected, unfortunately, that's the end of the road this year for that application. That H-1B won't be viable. So that person will have to seek out other opportunities, maybe an O-1 or some other option, a cap exempt option in order to proceed. So that's just an important thing to note. If you're on a J-1 for your training, so you're doing residency or fellowship in J-1 status, this H-1B cap likely won't apply to you. If you go through and get a J-1 waiver based on working in an underserved area, this is not something you will ever need to worry about. But for those of you who maybe get hardship waivers or persecution waivers, or who never had a J, you've always been in H-1B status, this cap stuff is important to know about. We're not going to do a deep dive on the H-1B cap tonight, but I did want to mention that there won't be a second lottery this year. Some other stuff that you may not have heard about in the news are what I've termed on this slide as wacky RFEs. An RFE is a request for evidence that the Immigration Service issues when there's something in a case that they need more info on, right? So we file a petition for an H-1B for somebody, we do everything right, and they come back and they say, well, we don't really like this, and they ask us for more evidence. And that can happen on any type of case that is filed with USCIS. Lately, though, we've been seeing really wacky RFEs. I think it's a combination of maybe some newer officers in the workforce who, were trained very, very quickly, not with a deep enough understanding of the law, and they've just completely misunderstood things. And a combination of that and an overuse and overdependence on AI tools to review petitions and issue requests. A couple of great examples that I can give you of both of these. There's a requirement in the H-1B context that an employer has to pay an employee at least the prevailing wage for the position. And that means like at least the average of what an American worker in that area, in that job might be earning. They have to pay them at least that, right? So the prevailing wage is a floor. And at the same time, if the employer normally pays a higher wage in that, let's say the prevailing wage is $100,000 a year, but this employer is really generous and they pay 150, they've got to then promise the H-1B worker 150, right? They can't underpay them what they would normally pay in that position. Okay, they can always pay more, but they can't underpay an H-1B worker according to all the documentation we have to submit. I got an RFE on an H-1B for an anesthesiologist that claimed that that my client was going to be violating the prevailing wage rules because the anesthesiologist was making too much money, that the prevailing wage was like $140,000 a year and he was getting paid $450. And they were like, so you're not complying with the prevailing wage rules because you are paying him higher than the prevailing wage. And I was like, no, that's not the way this works. And so I had to write this whole long explanation of all of these things of how the prevailing wage rules work and why my client was absolutely in compliance. And anesthesiologists are very highly compensated. And so like you're picking on a doctor who's like at the high end of the earning scale. And like, this is ridiculous. And the case got approved, but it took a lot of time to put all that together when the case should have just been approved. So that's one example of a wacky RFE. I had another one that completely got the type of petition we filed wrong, got my client's field wrong. My client was a pulmonary critical care physician, and they said that they were a marine engineer. Got the evidence that we submitted wrong. I mean, like everything about it was wrong. I submitted the meanest response I've ever submitted to anything ever in my career. And that case was ultimately approved. But I tell you this because there seems to be a lot of carelessness in what's going on. And we're seeing like weird things come out of the mailroom. We ship a petition out, it comes back, and like we can't figure out exactly what the problem is. We had that on a case today. So there's all these weird things going on. I tell you this because it's important to understand that these things can happen. And it may not be anybody's fault other than the officer at the immigration service who doesn't know what they're doing. And it doesn't mean that your case was prepared incorrectly. We have a lot of quality control in our office. A lot of people reviewing petitions and making sure that things are right before they go out. You do your best to make sure that everything is on point. You send it out and then something weird happens and you're just like, oh my gosh, just approve this petition. Like what's going on? So just know that this was something we saw in the first Trump administration. We're starting to see it again. And more than anything, it's just frustrating because it just wastes time. Really, it wastes our time. It wastes your anxiety. And so it really is not for any purpose other than to do that, right? To just make us all a little bit frustrated. One of the things that's kind of wrapped up in some of these wacky RFEs is back in early April, we started to get RFEs asking certain clients to go for biometrics appointments. And a biometrics appointment is an appointment at a USCIS Application Support Center, ASC, where you go in and you get fingerprints, a picture, and a signature sample. It's not an interview. It's just like an identity confirmation thing. In all of my years of practice, I've never had one H-1B beneficiary have to go for biometrics. It's just not a normal part of the process. We usually see biometrics on green card applications, applications for work cards, for travel documents connected with the green card process or similar processes. But we don't usually see it on H-1Bs or I-140s. Like it's just weird. So all of a sudden these start cropping up, and we immigration attorneys start getting very nervous. Does my client have some kind of criminal thing in his background that he didn't tell us about? Was it just a traffic ticket? Was there nothing? Like, what's happening here? And so in the beginning, attorneys were trying to send their clients to these appointments with an attorney because we were worried that people were going to get detained at these appointments. And it turns out, no, everything's been fine. They're coming infrequently and randomly. We cannot figure out why some of my clients have gotten these and why other ones haven't and what's going on. USCIS has never announced this as a policy, and they've not given any justification for needing these biometrics appointments. It could just be as an identity confirmation thing, where maybe some of the documents or information they have in their system aren't clear, but we just don't know. The silver lining on this is that nothing bad has happened at any of these appointments. So we've just been advising our clients, if this happens, go to the biometrics appointment. We'll respond to the RFE with your stamped appointment notice after you appear. And then the cases are getting approved like really quickly after we respond. So it doesn't seem to be anything to be afraid of, but it is something to know about because they seem to be coming up randomly in various cases. So be aware of that wrinkle in processing. And we're mostly seeing them on H-1Bs and I-140s. I-140s being a part of the green card process. So I haven't really heard of them coming up on O's or other, or L's or E's or anything like that. But mainly, and most of mine that I've seen have been on H's. And then the last thing I want to talk about on the less public developments is green card backlogs. And I've done presentations for Practice Match previously on the green card backlog. What does the visa bulletin mean? How to read the visa bulletin? Why do we have green card backlogs? All of that. So there definitely are some resources out there about that. But I like to talk about this every time I talk about hot topics because it's something that I think a lot of physicians don't yet understand or know. If you're from India or if you're from China, this is something that your fellow country people probably have talked about, right? I'm Indian, it's going to take me forever to get a green card, right? You know that there's some kind of wait. But if you're not from India or China, this is something that people who are your seniors, who maybe got green cards in the last 2 to 10 years, or even before that, who, or who are going through the process now, might not have any idea about, because if you're not Indian or Chinese, there wasn't a green card backlog until just a couple of years ago. And it really wasn't impactful until maybe the last year. So, if you start to talk about this with somebody who went through the process previously, they're gonna be like, what are you talking about? There's no green card backlog, but there is. And this is a function of the fact that the US government limits the number of green cards that can be issued annually in the fiscal year. They limit them by category, and then within each category, they're limited. No country can account for more than 7% of the green cards issued in any category. If you're from India or China, it's that 7% thing that you're butting up against. If you're not from India or China, you're butting up against just the category limit. Most physicians receive green cards in the EB2 category, and there is a backlog for everybody, regardless of country of birth in that category. And right now, in July, August, we can only finalize the green card process. So we could start the green card process, we can go through, and then we get to a stopping point. And right now, I can only finish out the process for people who initiated the process, who have priority dates in the system prior to September or October 2023. So, that's a decent sized backlog where there used to be zero backlog. So I have some clients right now who have priority dates in September 2023, and they don't finish their J1 waiver commitment until July 31st. So we cannot file the last stage of their green card application until they finish their J1 waiver commitment. And that would be filing in August. The August visa bulletin, we could only proceed if they had a priority date before September 1st, 2023. So if you have a September 9th, 2023 priority date, you're backlogged. So we've been, hoping and planning that we could file these in August. We cannot. I doubt we'll be able to file in September. My hope is that things will open up and we'll be able to file again in October when the new fiscal year starts. This is how the green card backlog kind of affects people and operates. I can't, we don't have the space tonight to do a deep dive on how this all works. Periodically through the year, I will always do a visa bulletin webinar with Practice Match because I know it's something that's kind of a mystery to a lot of people. But just be aware that this is something that exists. And as you are going through a job search, I think it's really important to be proactive about a green card process. Do not wait for your employer to bring you along and say, oh yeah, let's start this. You need to be your own best advocate on this. You need to ask about it during the recruitment process. You need to ask about it after you onboard if you hadn't gotten a clear commitment. It doesn't mean an employer has to sign on the dotted line and guarantee you they're going to start by a certain date. But I think the physicians who get really frustrated in this process are those who do not self-advocate and who make assumptions about when this process is going to start for them. And a lot of employers are waiting for the physician to kind of bring this up and say, hey, I would really like to go forward with the green card process. Can we get started on that? And the employer's like, yeah, great, let's do it. But everybody's a little different in what their interests are, what type of green card process they want to go through. Are you going through a spouse? Are you going to file through your employer? Are you going to do something else? And so nobody wants to make the assumption and just do that for you without knowing that you're invested in that process and you actually want it to happen. So I think knowing that the backlog is out there, I think, the earlier that you can advocate for yourself on green card sponsorship or how that process works and asking those questions, it's really important. Find out if a prospective employer has a policy. I have clients who have very specific green card sponsorship policies, and then I have others that really have no policy, and they kind of do it on a case-by-case basis as the physician brings it up. So understand that there are employers that are looking to you for guidance on what you want, as opposed to telling you what you should have. And I think that that's an important thing to realize in the process. I'm going to actually tackle a couple of these questions, and I know we're getting kind of late into the hour, so I'm probably going to leave. The rest of the slides in this presentation are really about J1 waivers. So before I dive into some of these questions, here's the big takeaway on J1 waivers I want you all to have, and on physician immigration in general. Nothing has changed in the law or really in practice on J1 waivers. So if you are a physician tonight sitting here on this webinar and you are in a residency or fellowship and you're in J1 status and you're starting to look for waiver jobs and learning how to navigate this process, the most important thing I can tell you is that about a good percentage, I don't know what the percentage is, probably about 70%, 80% of my law practice is J1 waivers and all of the things that come with J1 waivers, right? Like probably 95% of what I do relates in some way to J1 physicians. And we are still filing a tremendous volume of J1 waivers. They are all getting approved. They are all going through the system, most of them without any problems. And the ones that do have a little bit of sticking points where there are delays are outliers, right? There's something weird going on and we've got to kind of figure that out. On the whole, everything is going through the way it should. Thank goodness, right? We are not seeing whole, programs go away. Nothing has shut down. No states have said, sorry, we're not doing this anymore. The State Department's Waiver Review Division is operating more efficiently than I've seen it in a while. Immigration Service, maybe not as efficient, but things are moving. And we've did a ton of J1 waivers this past year. So I want you to understand that this process really has not been affected. Now, I say that knowing that a lightning bolt can now come strike me down because I totally jinxed it. But I think it's important to be very clear. We just talked about a whole bunch of craziness that's going on in the immigration system right now. This is one place where it's not all that crazy and things are actually going the way they should. So I want to give you that level of comfort that the process, nothing has changed. On H-1Bs, the biggest issue we're seeing are these crazy RFEs, and we're tackling them and we're winning, and our physicians are starting work. So, right, there are things that are going on that are frustrating and chaotic and anxiety provoking, and then there are things that are just going on kind of business as usual in the background, and that's where I'm living my life right now for the most part. So just be aware of that. In this presentation, I even said to my colleagues in the office who are also on our healthcare team today, I was like, I'm giving this presentation later, and I'm probably going to focus a lot on like non-physician specific stuff, because on the physician side, like everything's kind of normal, right? Is there anything that you guys can think of that isn't? And like everybody's like, nah, I think you're good. Like there are a couple of weird little things, but no. So that's where we are right now. That's a good thing. So, I know there was a big career fair tonight right before this presentation, and probably all of you had attended that. That's fantastic. Keep doing those things. Go through your job search, look for your J1 waiver jobs. They are there, and the process is still going forward. Nothing has changed in that regard. So I'm going to go ahead and tackle a few questions. We have a question here. Do you think visas are generally easier to get approved if you are from countries that are like the US, like the UK, Germany, Australia, etc.? That's a hard question to answer. I don't know that it's easier. I see um, in both my practice and in colleagues' practices, there are folks from the UK who are coming here on O1 visas to work in media, right? Who are coming to work in TV or in music or whatever, and they're getting tripped up sometimes on those applications. We see folks coming from, we see posts sometimes, consular posts at times that will crop up and be really horrible for a little while. And then that one rogue consular officer rotates to somewhere else, and that somewhere else becomes horrible, and the place that they were loosens up a little bit and things get better. So no, I don't necessarily think, it's not like everybody who applies for a visa in Western Europe automatically gets their visa. Is there heightened scrutiny in certain places? Yes, of course there is. I think there are certain posts where there are high incidences of overstay, where, Jamaica, Nigeria, the post in Manila is notoriously, challenging. There are some places where there is heightened scrutiny. But I don't think that's, but I would not want to lead you to believe that if you're from Australia or England or something, oh yeah, you're definitely getting your visa and everybody else is going to have a hard time. That right now in this climate, the scrutiny is system wide. And regardless of where you're from, I would take a consular appointment very seriously and prep for it, and make sure that you know what you're doing. How scared should we be about traffic tickets, and will it affect visa approval, future green card approval, random arrest, deportation, etc.? That's a great question. Technically and legally, a traffic ticket should have absolutely no effect on anything, unless so long as it did not rise to the level of a criminal offense. I know in some places in the United States, for example, if you are speeding above a certain amount, that ticket becomes like some low level, or some high level misdemeanor or low level felony. Those things can be a challenge. But if it's like I ran a stop sign and it's just a citation, that should not keep you from getting a green card. It should not keep you from getting a visa. It should not keep you from becoming a citizen ultimately. However, there are some places in immigration world where there are questions that ask you very broadly, have you ever, anywhere in the world, right? Have you ever been arrested, charged, detained, cited, right? There's a question I know on the naturalization application. I think it may also be on the green card application about whether you were ever cited, right? It's a long list of words: arrested, charged, detained, blah, 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 cited. A traffic ticket is a citation. And so a lot of times on those applications, we will disclose traffic tickets, not because they are a bar to the benefit we're trying to get, but because it is better to disclose it than not disclose it. Sometimes our clients, the traffic ticket was so long ago, they don't have those documents anymore. We disclose it anyway. We say, so-and-so got a traffic ticket. They can't remember the year. It was in this place. This is what it was for. They can't get the documents. But we just wanted to disclose it out of an abundance of caution. I would rather do that every day than to try to hide it and not disclose it. Now, if it's an application where you're not asked that question, you do not have to affirmatively tell the government, hey, I got a traffic ticket, right? We want to be truthful in our answers to questions that are asked, but we don't necessarily need to go and like run to the government and say, by the way, here's every traffic ticket I ever had anywhere in the world. I know you didn't ask for it, but I thought you might want it, right? Like that's not what I'm advocating for. But yeah, I mean, if you're filling out an application that has that question about being cited, I would disclose traffic tickets. We do know that, or we surmise, I shouldn't say we know. We surmise that some of the student visa revocations, some of the biometrics notices are because the government pinged a particular database where any law enforcement interaction is recorded. And we think that somehow, people who only ever had a traffic ticket that didn't rise to the level of a crime got swept up in this because they were using AI tools to ping that database and they weren't being discerning about what they were doing on the back end with it. So yeah, I mean, that could be out there, but from the legal, on the legal perspective, traffic tickets should not cause an arrest. It should not cause you to be deported. It should not cause a visa revocation. It should not cause denial of a benefit. As I said, so long as it wasn't like a DUI or something that rises to the level of an actual crime. Let's see. I'm going to scroll down here. Oh, I missed a whole bunch of stuff down here. Hold on. Okay, let's see. Current timeline for J1 waiver paperwork. So if we're talking about an underserved area waiver, I just want to be mindful of time. If we're talking about an underserved area waiver, I usually say you need to budget about 7 months for that. With the caveat, it really depends what time of year you're applying. If you're applying, October 1st, well, I shouldn't say that. It depends on the time of year and the program you're applying to, because all the programs have different deadlines or times for when you need to apply and different timeframes for how long they take to adjudicate. So 7 months is a great rule of thumb. Your case may take less time. It may take more time than that, depending on when you file and where you file. But that's a good estimate for you just to kind of have in your mind. I think, would you mind elaborating on people looking for J1 waiver jobs? Should we be asking about green card assistance at that time? And I think the answer to that is yes. Even if it's just an open-ended question to a recruiter, can you tell me what your practice's policy on green card sponsorship is? They may say they don't know. They may say, well, they don't really have one, or they may have a very specific policy. It's great to know that. If you get a chance to consult with their immigration attorney, you can ask the immigration attorney that question as well. I get asked that all the time. And depending on the client, I will go through what that policy is, if I know what it is, and kind of have a discussion about, what to think about when it comes to green card sponsorship. Let's see. Oh goodness, that's it. Okay, there's a very lengthy J2 question. I may have to ask you, that one's a little bit too complicated for this scenario. I would say, a PNIW application filed at the same time as a J1 waiver application is a great way to get your spouse an H4 EAD when your waiver is approved, so that when you switch from your J1 to your H1B so that you can work in your waiver job, ideally you will also have that approved I-140 based on the PNIW, and your spouse can use that to get an H4 EAD when they switch to H4 status so that they can work as well without sponsorship. For those of you who have no idea what I'm talking about, a PNIW is a Physician National Interest Waiver. It is a green card process based on working 5 years in an underserved area versus the 3 required for a J1 waiver. And a lot of times we can go through that process in such a way that our J1 clients, spouses, can start work around the same time that they do. So that's certainly a tried and true pathway and strategy that we use a few times every year. No, an NIW does not have an expiration date. So, if you have if you have an approved NIW and your priority date is current, but let's say you're doing your J1 waiver service or you're in J1 status, and so you can't file an adjustment of status yet, you can wait until you finish your waiver service and then file your adjustment of status application. So long as your priority date is still current at that point, the NIW won't expire. You may get a question from USCIS about whether you're still working in the field and are still advancing the endeavor, things like that. But in general, that I-140 approval never expires. So you have some comfort there. We have that happen a lot of times on EB1s as well. And I've even had cases where spouses are processing at different times, and we can go back. Right now I'm doing it. I'm going back and using an I-140 from like years ago for a spouse who just finished a J1 commitment. Let's see. So, if you're having trouble finding a J1 visa appointment, it can be challenging to get visa appointments. The State Department's official position is that you can go anywhere in the world to apply for a visa, as long as you can gain admission into that country and, you can stay there through your visa issuance, because the embassy will have your passport. The one caveat to that is when it comes to J's, because an embassy has to consider your home ties, right? It's a non-immigrant intent visa. So they have to confirm that you have the intent to return home and that you have proper ties to your home country. Sometimes if you go someplace like Canada or Mexico or wherever, they're like, oh yeah, we can't assess this. Now, if it's not your first J1 visa, if you've had a few of them, and that may bode better in your favor. But yeah, you're not required to go back to your home country every time you need a visa stamp. There's just a little bit heightened risk that you could get refused and they say, no, we want you to apply at home. So, you can do that. But I have plenty of clients that, look in various places to see where they can get the best appointment time, if they can't get one in their home country. And most of the time it works out okay. Just make sure that you have the ability to stay in that country for a little while, so that if it takes a little extra time to get your passport back, you're not running up against the clock in that country for how long you can stay there. See. So yeah, H-1Bs shouldn't be denied on immigrant intent because it's a dual intent visa. So I don't really understand what happened in the example that's provided in this question, but the embassy doesn't have access to your bank account information. We typically advise bringing some, if you have to prove home ties, like you're, applying in the J1 or F1 category or TN category, if you're coming from Mexico or at the border from Canada, that you bring evidence of financial ties to your home country. So there may be people who go to their visa appointment and show, oh, look, I bought a house. I have, I'm well-to-do, or I have enough ties to my home country. I wouldn't necessarily, show tie. If you're applying for a J1 visa, showing ties to the US is not really what you're trying to do. You need to show ties home. On the H-1B, that shouldn't be an issue. But no, the US government cannot like ping your bank accounts, as far as I know. That should not be a thing. Let's let's see. I'm going to try to just cover a couple more quickly because I know we're really running out of time. Um, let's see. Yeah, with the this will be the last one I'll probably be able to cover tonight. And I think it's a really good question. Um, and it is okay if you're on a J1 waiver job to buy a house. If you're working on a J1 waiver job, you're in H1B status. It's not a problem to buy a house. But that wasn't the one I was talking about. There's a question here about why are lots of J1s being rejected for new doctors entering residency this year, lots of 214B. And I think that goes back to what we discussed at the very top of this hour about a real incidence of using of the State Department using 214B to deny J1s. They have lumped J1s and F1s together when it comes to that social media vetting. And if they're going to deny you based on a social media vetting, the consular officers are directed to use 214B as much as possible because it's very difficult to challenge that. The consular officers get a ton of discretion to deny on those grounds because they basically can just say, you don't qualify. And they don't have to tell you why, and you don't get a chance to dispute it. So, that's my impression. I think as we get, we're pretty far into the summer now, and a lot of students are going to try to come, F1 students are going to try to come to the United States in August or soon, to start school this fall. And I think we'll see, I would assume and expect that we would see similar 214B denial rates on F1s this fall as we are for Js, and maybe even higher rates. Right now, the State Department is really hostile to Fs and Js. And it goes back to, the CVIS terminations that happened earlier this year that were primarily on students, but because J1s can also be used by certain students, the State Department has kind of glommed onto that and tried to paint J1s and F1s all with the same brush, and Ms for that matter. Folks in M status come to participate in vocational or technical programs at schools, and they've kind of painted them all with the same broad brush, even though, as we all know, Js are very different, right? It's a very different animal than Fs or Ms, but they're being lumped together. And so that's my uh, that's my assumption as to why we're seeing those increases in 214B denials on Js. So anyway, I know we ran over the hour. It was a lot of information to cover, but I thank you all so much for your attention, for your fabulous questions. I am so sorry I couldn't get to quite all of them, but thank you so much for joining.
Yes, thank you, Elisa. For everyone, like I mentioned at the beginning of this webinar, we are recording, so I will have this recording link sent to everyone by the end of the week. Thank you so much, Elisa. We also do have another webinar, not the exact same topics, obviously, but we'll have another immigration update in October. So you can all register for that as well with Elisa. She'll be back to answer more questions and talk about more what's going on in the immigration world. So thanks so much, everyone, for joining us tonight. Thanks, Elisa.
Thanks, Rainey. Bye.
Okay.